Greetings, dear colleagues, candidates, and the public. Today, on January the 19th, 2025, the advisory group of experts gathered to interview the candidate for the position of a judge of the Constitutional Court of Ukraine, Krasovskyi Kostiantyn Yuryovich. In particular, members of the group are present: the member of the group Hanna Sukotska, Yaroslav Romanyuk, Alesh Zalar, and Vasyl Shakun. We have also the secretary present, Maureen O'Connor, and myself, the chair of the group, Oksana Vasilchenko. The interview is also attended by deputy members of GE, Volodymyr Kuzmenko, Marek Zubik, Richard Barrett, Vitaly Makhinchuk. I should note that we were working in a shelter, so in the event of the air raid alert, the interview will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live on the AGE resources and the CCU website. I would like to draw the attention of the AGE members and the candidate to the request to restrict the use of sensitive data and restricted information during the live broadcast. If it is necessary to discuss such issues, the AGE will restrict the broadcast for that time. We are now ready to begin, so I would like to pass the floor to Secretary of the AGE, Madam Maureen O'Connor, for a brief introduction of the candidate and a reminder of the interview rules procedure. Madam Maureen, the floor is yours.
Oops. I can't get this on. Let me see your paper. Oh, you have one. Thank you, Madam Chair, and greetings, dear colleagues, and everyone who is watching us. Our chair has already said and informed us that the advisory group of experts will now interview the candidate, Krasovskyi. Let me remind you that an interview is the opportunity to interview is a mandatory stage in the assessment of candidates as part of the evaluation of their compliance with the criterion of high moral qualities. The time limit for our interview will be no more than 1 hour, and the time limit for answers for each question will be no more than 3 minutes. Traditionally, we would ask all candidates to be concise and to answer clearly and to the point for the questions asked. At the end of the interview, the candidate may make a short closing statement of no more than 5 minutes. I would also note that while processing the materials of candidate Krasovskyi, the advisory group of experts sent him questions for written explanations, so the candidate has had an opportunity to both prepare and to provide answers. So now we have with us a candidate for the position of Judge of the Constitutional Court of Ukraine. Mr. Krasovskyi, who was admitted to the selection process by the Selection Commission, is affiliated with the President of Ukraine. He joined the military in March of 2022 and has held various positions and is currently an officer in the legal department with the rank of Lieutenant of Justice. Prior to his military service, he worked as an attorney, legal advisor, and expert for international technical assistance projects. He has experience in civil service at the Ministry of Justice for Ukraine and the Presidential Administration of Ukraine, and he holds the third rank of civil servant. From 2007 to 2008, Mr. Krasovskyi studied at the Maxwell School of Citizenship and Public Affairs at Syracuse University in New York, USA. He holds a PhD in law, having defended his dissertation on natural human rights in Ukrainian constitutionalism in 2021. Mr. Krasovskyi, if you would like to add anything to your background information that I have just gone through, you may do so now with up to 3 minutes.
Дякую за можливість.
Thank you for the opportunity, but you have described enough. You have described my experience, so thank you.
Шановні колеги, прошу ставити запитання. Пан
So, dear colleagues, please ask your questions. Mr. Alish.
Good day, Mr. Krasovskyi. I have a question which relates your property issues. As you have informed the advisory group of experts, you have been registered as a self-employed person since 22nd of April 2020 with the aim of starting your own individual practice of law. At the same time, according to your CV, you resumed your private attorney practice in September 2019 and have been working for international technical assistance projects since then. Could you explain us why you have not registered as a self-employed person since September 2019?
Thank you for your question. I have upgraded the certificate in September 2019. I did not work with expert organizations as of September 2019 up until April 2020. I answered this question during our written phase. Thank you.
Thank you. I'm aware about your answer. I just want to recheck whether you insist on this statement. So my next question is, did you provide services as a lawyer or as an expert of international technical assistance projects from September 2019 to 22nd April 2020? So did you provide service as a lawyer or as an expert of international technical assistance in this short period of time?
Дякую за запитання. Якщо я
Thank you for your question. If I understood your question correctly, you're asking me whether I, as a self-employed person, as a lawyer and as an expert, provided services to organizations from September 2019 till April the 22nd, 2020. Is it correct?
не надавав такі
As an expert, I did not provide such services. I had another activity, and we have discussed this at the previous meeting. I worked as the director of administrative cases.
Okay. You informed the advisory group that in year 2021, you received a little bit more than 200,000 Ukrainian hryvnias of income as a self-employed person. You also indicated this amount in your electronic declaration for year 2021. At the same time, the advisory group does not have any information that your tax return for a year 2021 has been filed. Do you confirm the circumstance of the non-submission of such a tax return?
Thank you for your question. If we are talking about 2021, I had an obligation to file the tax declaration in 2022 for 2021. So we are talking about this, right?
Ask you about your electronic declaration for year 2021 in which you stated your income. So we would like to know whether your tax return, which relates to this year 2021, has been filed.
In 2022, in my declaration as a person authorized to fulfill functions of the state, I declared this income for 2021. So yes, in one of the declarations, and the issue of the tax declaration. I did not specify that because the war started, I was mobilized, I volunteered, and I did not have a chance to do that. And according to the tax legislation, I will file this tax declaration after demobilization, and I will pay respective taxes and insurance contributions that I have to pay.
Thank you. In your electronic declaration for 2023, you stated that your son received 103,000 Ukrainian hryvnias of income from the alienation of movable property. At the same time, in the column source of income, it is indicated that family member did not provide information. What kind of movable property did your son receive this income for sale of?
Thank you for your question. My son sold his vehicle and received this income from the sale of that vehicle. Back then, while submitting the declaration, I did not have documents that would confirm this sale. So that is why I chose this particular file in the declaration. While answering questions of the AGE, I asked my son to provide this copy. He received a copy based on of the power of attorney based on which the sale was performed, and I provided this information to the AGE.
And that was the vehicle smart car, right?
Є-
Yes.
Okay, thank you. I will pass the floor now to my colleague, Vasil Shakun, and I ask the chair to start with the closed part of the interview and with restriction on broadcasting. So, Vasil, I'm passing the floor back.
Зараз про
1 second. Please suspend the broadcast since questions are about
Dear colleagues, let's ask questions. 1 minute. I would like to ask one question. The abstract from the official characteristics in the military unit where you serve now. And here it says that he knows and applies the statute in practice, organizes the work on elaborating documents and plans in accordance with a set list and in accordance with the planned measures. Uh, or necessary time for preparation of the means and equipment. The documents are provided in timely manner. You spoke about one type of work, but in your characteristics, it shows something else. Thank you for your question. I do not see any difference. This is combat activity, including in the operational and tactical group. We are in the open mode now. Oh, sorry. I see. Thank you. Mr. Alish.
Yes, do you hear me? Because I wanted to ask a question under the closed part of our session. Is it still closed or it's broadcasted now? Can somebody explain?
So We are back.
Пане Алиш, прошу.
Mr. Alish, please, the floor is yours.
Thank you. My next question refers to your employment in the presidential administration. In December 2014, you started working as the head of the main department of legal policy of the presidential administration of Ukraine. Part of the previous competition, you reported that you had passed the competitive procedures for this position. At the same time, according to the legislation in force at time, this position belonged to the second category, for which civil service recruitment was not carried out on a competitive basis. The Office of the President of Ukraine also informed the advisory group that for the same reason, your appointment was made without competition. So, what kind of competitive procedures were you referring to?
As far as I remember, that was 2014, 10 years ago. But as far as I remember, there were several candidates for this position, and respective interviews were held with deputies in the administration of the president, with the head of the presidential administration. As far as I remember, there was competition for this position, and I was not one candidate only who was considered for this position.
And, according to your job description, your appointment was made on the recommendation of the deputy head of the presidential administration, to whom you were directly subordinate. I'm referring to Alexei Filatov. As you have informed the advisory group, you knew him and worked with him from the period of 1999 to 2002. Would you describe your relationship with Mr. Filatov as friendly in 2014?
Thank you for your question. In 2014, we already cooperated within the framework of working groups starting from September and to December, and among other things, as members of the Council on the Judiciary Reform, where I was the secretary. So these were deep professional relationship.
Did the fact that Mr. Filatov was then deputy head influence your decision to start working in this body?
Yes, because I started working in the Council on the Judiciary Reform. I received several offers to work in the business sector, but since I already agreed to work for the state, I decided for myself that my path would be in public governance, and moreover, my American education, I went there in order to get the best experience of management and governance in the civil service, so that they could be applied during the reform of the Ukrainian legislation, of the Ukrainian system and the Ukrainian state.
So don't you think that an objective observer might get the impression that you used your personal connections to hold a high public office?
I would not agree with this approach, because an objective observer, if we look at my career before this position, it's logical, because I responded to the challenge that existed in the Ukrainian state in 2014, and those calls that were voiced by civil society organizations, including the Professional Association to graduates of Western universities, and they called upon to help the state. It's clear that since 2009 to 2014, I worked in the private sector, and to use my work in the private sector. If I continued working there, I would have earned more, but I wanted to apply my knowledge.
I have another set of questions. From December 14 to September 19, as the head of the main department of legal policy of the presidential administration of Ukraine, you, we could say, actually implemented the judicial reform. Obviously, we could talk about its implementation on behalf of the president. In your opinion, what is the role of the president in judicial reform?
Thank you for your question. That's a very interesting thing to consider. Right now, looking into the past, where the role of the president and the fact that he founded this council on the judicial reform for the reform, that is a systemic approach, the opportunity to impact the politics of the state development in the correct direction, in the direction towards democracy, rule of law, and human rights. And based on those tasks that were given to us by the decision under the case of Volkov and other judgments of the European Court of Human Rights, to change the judiciary system in such a manner that it would give it an impetus to develop further for Ukrainian citizens and for the Ukrainian society.
May I ask you if members of the presidential administration, including you at that time, interfere in the process of forming the Supreme Court or in other processes related to judicial reform?
Ні.
No. No, not. They did not influence that. I can tell you that openly.
Два прозорих.
These were two transparent competitions to the Supreme Court, transparent competition to the Anti-Corruption Court that's recognized by European and international observers. And it has been recognized by the Venice Commission and by projects of the Council of Europe.
Yes, I'm very well aware because I was part of this process as external expert. I have another question. In your opinion, do you think it's appropriate for judges to hold meetings outside of working hours with representatives of other branches of government?
Can you please repeat the question? Sorry, I did not hear it.
This is a general question. What do you think? Is it appropriate for judges to hold meetings outside of working hours with representatives of other branches of government? I'm actually referring to the report about such connections one day in the November, actually this was the last November 2017, about 7 o'clock in the evening, when Ivan Mishchenko, and I think you already mentioned him, a newly appointed judge of the Commercial Court of Cassation of the Supreme Court, visited the presidential administration. And according to this judge, he met with you. How can you comment on this?
Так, я підтверджую нашу зустріч і не
Yes, I confirm our meeting, and it was about my role as the secretary of the Council of the Judiciary Reform, and Mr. Ivan back then had some suggestions regarding reforming of the commercial procedural legislation.
How long you know the Judge Mishchenko?
We used to work in 2003 in the Ministry of Justice, so I know him from there.
А потім
And then I went to study in the US. I no longer worked in the Ministry of Justice, and then I knew him based on my work in the Council on the Judiciary Reform.
And did other judges, either from the Supreme Court or other courts, also came to you for meeting and to discuss certain issues.
Так, якщо у них були
Yes, if they had suggestions for respective draft laws. It happened within the framework of working groups and in the form of discussions.
Do you think the public would react on such informal relations? I already referred to the report of journalists, for example, Radio Liberty, which published a special report on your contact with that judge. So, what do you think? How the general public see this? Do you see any problem from the perspective of the appearance of independence of the judiciary?
Якщо ми
If we consider this issue in some specific context of some specific case, then yes, it's a problem. But in this particular instance, this problem does not exist there. I do not see it there.
Thank you. I have no further questions.
У мене є.
I have some questions. Yes, colleagues, please. Vasil. I have the following question. During our previous interview, you were asked questions about your attitude towards the judicial reform that you were responsible for. In response, you said the following approximately: that you believe that it was your best achievement and you were proud of it. You know the destiny of this reform better than me, probably, and I have the following question. You know, today we are not talking about some technical issues. We are trying to assess your qualities, moral qualities, so that you, if God allows that, become a judge of the Constitutional Court, so that you could defend interests of Ukraine and the people. So I have the following question. Have you changed your opinion about the judicial reform that was recognized as not very effective? Thank you for your question. I think that we will agree. And last time I provided those conclusions of the Council of Europe dated 2019 that were saying that lots of things could be implemented. It was possible to change the paradigm in the justice system in Ukraine, and this is recognized by international organizations as the correct one. Lots of things failed, and there are different reasons for that, because reform is always the issue of adoption of decisions by political bodies, and where political fight is ongoing. I'm a technocrat. I applied my knowledge from public administration and public policy that I received both in Ukrainian university and in the American university. But I think that back then, when in 2019, when I left it, there were results, and they gave their outcomes. And even the justice system became closer to the society. It became clearer for the society. It's clear for me. I just want to say that if you believe that a success of this judicial reform is the fact that the Supreme Court and specialized courts were filled in with judges of a specific attorney's company, then that's success of this law firm, but not Ukraine. If you allow, Mr. Vasil, we can debate regarding this issue, but I think that with respect to this assessment. That is always subjective. But please agree with me that transparency of the judiciary and those new judges that came to the system have allowed to increase the level of trust of the society in the judiciary. If you allow, Mr. Kostiantyn, let me ask one question. The AGE has received an appeal from one of the civil society organizations. Among other things, they are drawing attention to your dissertation. I will quote a few sentences and please comment on them. Ideas regarding natural human rights highlighted in the dissertation are available in other academic papers available through educational resources. Coincidences are revealed in general statements which are not unique for the paper of Krasovskyi, because these are generally accepted parts of the academic discussion. Fragments of the text, especially the ones that discover the theory of development of the concept of natural human rights, show many borrowings from universal academic sources, which is not typical for dissertation researchers. How can you comment on this statement of the civil society organization? Because in fact they are reproaching you of plagiarism. Thank you for your question. With respect to plagiarism, we discussed it last time as well. In my dissertation there is no plagiarism. This is probably the question about academic novelty and not plagiarism, but I do not fully agree with this, because where I needed to put quotes, I quoted them, I included references. My academic research was aimed at achieving this academic novelty in this particular issue, so I disagree with this subjective view, and I think a bit manipulative statement of honorable civil society organizations. I managed to defend my dissertation in front of quite professional and commission. Thank you. Dear colleagues, do we have any other questions? Yes, please, Madam Marine.
I have another question, and it relates to your relationship with colleagues. There have been questions about your relationship with Judge Mishenko, Mr. Filatov, and I'm not sure that there's not another one. Anyway, my understanding is that these were people that you worked with in various capacities in your career.
Так.
Okay.
Yes.
Did you have more than a professional relationship with them? In other words, did you have a social relationship? Did you meet for social activities with these people?
With these particular people, no.
Was there a requirement that you sever relationships with prior colleagues, given your position with the legal policy of the presidential administration of Ukraine? In other words, that you were not permitted to meet one-on-one, individually, with anybody that you had previously enjoyed a professional relationship with?
If I understand your question correctly, you're asking whether I was allowed to meet with my former colleagues. I did not have any prohibitions regarding that.
You're aware of a statement from the Chief Judge of the Supreme Court that said, of course, I quote, "Of course, everyone understands that we should not have any business in the presidential administration, and secondly, we should not give the impression that we have business there." And this was in relationship, I guess, to the activities of Judge Mishenko. Is that, actually, that statement would reflect for the judge, but not for you. That's the way I would read that.
Ну, для мене
For me, it's easy to answer this question because we really discussed issues, as far as I remember, regarding amendments to the procedural legislation, which was amended in 2017, I think. It was the key for the next stage of the reform. For me, it was interesting to learn about his opinion and the opinion of other prosecutors, judges, attorneys, of how to further reform and how to find the best system for procedural legislation.
That information, I'm presuming, enhanced and helped your role in the president's service when it came to perspective and how you can, what your recommendations would be. In other words, you understand what the judges want, the prosecutors, as you just mentioned. It's important for you to have gathered that information.
для мене
It was important for me to understand the opinion of the practitioners on how the theoretical norms that we were discussing at the Council, the judicial reform, can be implemented in the specific legislative project, in the specific legislative norm practice work.
Шановні колеги,
Dear colleagues, are there any other questions for the candidate? If there are no more questions, Kostiantyn Yurievich, you get 5 minutes to do a short closing statement. Thank you. Dear members of the AGE, I would like to express my gratitude to you for having objectively studied my candidacy from the position of high moral qualities and standards. I would like to remind that 6 months ago you told yes to my attempt to prove the reasonable grounds of my reasons to become the judge to the CCU. Thank you so much for such evaluation. Only due that is not related to me, only due to the combination of circumstances I could not complete that procedure. During these 6 months I did not become any worse, and I can assume that such a type of a break allowed me to do the rethinking on my preparation to become the judge of the CCU, that I benefited from it. I have managed to digest a lot and to clearly understand that I accept this challenge. I'm ready to work for the good of the society, the state, defending the Constitution of Ukraine. I would like to assure the dear AGE members and the public that my knowledge, skills, and my professional experience in the sphere of law I will use to achieve these goals. And finally, I will make a statement that refers to the Constitution and that reflects my position in many ways. And it is related to the parents who are founders of the USA. I will quote, if I may: "The strength of the Constitution completely lies in the decisiveness of each of the citizens to defend it, to protect it. The constitutional rights are protected only in that case when the citizen considers its obligation to make their contribution to this protection." I completely share this position, and I'm thanking you for the attention. Thank you, Kostiantyn Yurievich, for your answers. Dear colleagues and the public, I hereby declare the interview with the candidate for the position of the judge of the CCU, Mr. Krasovskyi Kostiantyn Yurievich, completed.